Hey class, well you have made it to week 16 and this is the last lecture of the semester. So thank you for sticking with me and staying engaged in this class, even though these are some interesting times and I know that all of you are busy with work and family, just trying to get by with the pandemic. So thank you. Today's lecture is going to be a pretty short one. We are going to discuss how to most effectively use the legal resources that are available to you within your organization. So I'm going to be talking about how to work with counsel at a government agency, but this holds true for other organizations as well. So I'm going to focus on the civil administrative law side of the legal profession where it comes to attorneys. So I'm not going to cover like district attorneys, public defenders, or the vast majority of attorneys who work for the U.S. Department of Justice. So this is more for in-house counsel at an agency or a nonprofit. So legal offices, we go by a variety of names. Most often, you're going to see the Office of General Counsel. That's usually standard. Now, at the state and federal level, you'll have an Office of the Attorney General, which more than likely handle litigation for your agency. At the city level, you'll often have a city attorney's office, but that functions much like an Office of General Counsel. Other names might be Office of Chief Counsel, Office of Legal Affairs, agency or in-house counsel. So lots of different names. Also a lot of different sizes. The size of a legal office really does vary by organization. At federal and state levels, there's going to be the Office of the Attorney General. That's going to have your chief legal officer for the government and a bunch of assistant attorney generals to provide advice to agencies that do not have their own in-house attorneys, and also to help with litigation and actually litigate cases on behalf of the government agency. Now, usually cabinet level departments and the agencies within those departments both have their own legal offices. And then agencies that have field offices, such as FEMA, they actually might have smaller legal departments embedded in each field office or embedded in a regional office. And the number of attorneys at any organization can really range from 1 to hundreds. I have worked for research and development nonprofit. I was the only attorney. I eventually got a paralegal. I have worked at a big law firm where obviously I'm just surrounded by other attorneys. Right now, as I work for a public university, there are 9 of us who are attorneys, plus we have a paralegal and 1 administrative assistant. So it really varies. For the size of the University of Maryland College Park, we actually have a fairly small legal office. Most universities of a comparable size and research and athletic portfolio have closer to 20. So we are understaffed, but that is not unusual for government attorneys. All right, so let's take a look at the type of work that a typical Office of General Counsel does. So obviously we provide legal advice and on a wide variety of matters, including how the agency or other organization should implement and comply with applicable statutes and regulations, how it complies with government policies, such as those that are set by the Office of Management and Budget, basically any policy that would impact the agency, as well as the agency's own policies and procedures and contractual obligations. We handle a pretty wide variety of internal matters, so that includes providing advice on proposed internal policies and procedures, participating in internal audits and investigations, representing the organization in employee grievance hearings, and serving on a variety of committees and task forces that guide and assist decision makers. We also negotiate contracts. Sometimes we do that on our own. Sometimes we're part of a negotiating team that includes another agency office, such as procurement. And we provide training on contract compliance. We draft or review legislation, regulations, policies, white papers, all kinds of things. We serve as a sounding board for agency leadership or other agency personnel. So that mixes legal and business advice to such a degree that as an attorney, we've got to be mindful of maintaining attorney-client privilege, which we will discuss shortly. And then finally, we are expected to kind of constantly monitor the legal, political, and operational environment and flag issues that we see coming down the pipe. Because the legal office tends to work with many different parts of an agency, the legal office often serves as kind of an informal nexus of information and helps bridge the gap between organizational silos, so we connect people who may not be aware of their common interest, and we kind of try to avoid an organizational left-hand, right-hand problem. The legal office covers a wide variety of subject matter. Obviously, every government agency needs in-house counsel who understands administrative law and regulatory compliance, as do all government contractors. Agency legal offices should have attorneys who know contract law, both government and commercial. These are entirely different fields with different sets of rules. In my experience, which admittedly is biased because it's my field, government contracts attorneys can handle commercial contracts, but it's much harder for a commercial contracts attorney to handle government contracts. Because government agencies at all levels are bound by the U.S. Constitution, they need attorneys who understand constitutional law, especially First Amendment and Fourth Amendment law, plus their specific state's constitutional law if it is a state agency. The public sector, both federal and state, has a lot of employees, so the legal office has to know employment law, as well as applicable privacy laws, and understand how those laws apply to unionized personnel, as well as non-union professional exempt personnel. Because agencies purchase and lease land and buildings, they also sometimes lease out their own land and buildings. Agency legal offices typically need a real estate attorney. They also need attorneys who specialize in tort law, both because all of that real property is a fertile ground for trip and falls and other tort cases, but also because government agencies are covered by a state or federal Tort Claims Act. So you need somebody who knows torts. These are just some of the subject matter about which agency attorneys provide advice and counsel. There are many more, including technology law, accessibility and ADA compliance, intellectual property law, and then specialized areas that are critical to a particular agency's operations, such as water law or maritime law or environmental law. Additionally, attorneys have to be concerned about our own ethical behavior. Lawyer jokes aside, we really are held to a high standard of professional ethics, and we'll lose our license to practice, and thus our livelihoods, if we act unethically. But we are also concerned about public ethics laws that apply to our organization and its personnel, because we need to keep our clients in line with ethics laws. I spend a good amount of time advising my university's personnel on whether they can accept certain gifts or other freebies from companies that do business with the university. So here in Maryland, our public ethics law allows state employees to accept, what we would call gifts of conference registration fees, travel, hotel, and food costs from companies, like a Google or a Microsoft, if the employee is going to be a speaker or panelist. Otherwise, they can't do it. So I spend time kind of trying to thread that needle for my clients. Public ethics law is also especially prevalent at the federal level, where the federal government wants to avoid a revolving door, where government officials leave federal service and immediately land cushy jobs in lobbying firms, that lobby their former agency, or in companies that are regulated by their former agency. So there's usually this cooling off period of at least a year before a federal official can take a job, and oftentimes the agency's legal office is going to be involved in that. A day in the life of a government attorney, it really varies by agency, but I can tell you what I do in the state government at a university. So I get in, I take a look at my to-do list, I quickly review any emails that came in overnight, and I prioritize which ones I'm going to respond to. Check my calendar to know what meetings require me to prepare for something. Then I check for recent news about my university specifically, or anything that would impact universities generally. By then, I've had a cup of coffee, so I dig into my to-do list. And most days, I've got to deal with something urgent that then destroys that to-do list. There are plenty of times when these are imagined emergencies. Somebody thinks that their project is the most important for the whole university, but it's not. Or emergencies that were sort of inadvertently manufactured by waiting too long to contact me. But unfortunately, large organizations do have a steady stream of actual emergencies, actual urgent matters, as well as this kind of crazy, 5-alarm fire emergency that we've got with the COVID-19 pandemic. There are attorneys who spend most of their days in their offices, but for me, because of the different types of campus units and operations that I support, I tend to wind up in a lot of meetings throughout the day. These can range from standing committee meetings, like for instance, I provide legal advice to our science diving board. That's for our scuba divers who are engaged in scientific research, or our conflict of interest committee. But they can also be quick meetings with leadership, meetings about contract negotiation strategies, or just one-on-one meetings with clients, either in person or, well, now Zoom, or via a phone call. And after each meeting or other interaction with a client, I usually have some new action items added to my to-do list, which means that I then have to reprioritize that list. There are also a lot of times that I have to redirect business decisions. So by that, I mean decisions about how to proceed operationally, and I've got to direct that back to the appropriate client. Especially in uncertain circumstances like we're seeing now, decision makers often want legal to sign off or otherwise bless some decision. And that's an understandable desire, but attorneys are there to provide legal advice, not make those business or operational decisions. I personally spend an enormous amount of time writing. I draft or revise contracts, policies, procedures, reports, memos, plus I just write a huge number of emails every day. And what I've tried to do for class is gear the assignments in this class towards something that you might need to write at your own job in your own agency. And I do want to take this opportunity to really stress the importance of clear, concise writing. Everybody is busy, and you're more likely to be heard if you can communicate quickly and clearly. For me, for reports and memos, I always write a first draft that gets out all of my thoughts, all of my legal analysis, and all of my recommendations on paper. And then I spend time like viciously slashing it down to the bare minimum that my clients need to understand the situation and make an informed decision. So just as an example, last week I wrote a task force report. The original report was like 40 pages, and I slashed that thing down to 14 pages and a 1-page executive summary, because even though the rest of it did have some importance, I know that my clients are really going to be pressed for time. They're going to appreciate that 1-page summary, and then the ability to kind of page through that 14-page report rather than me dropping 40+ pages on them. If you write well, people are going to take notice, and they are going to view you as a knowledgeable resource. So that's why I've really stressed the importance of writing. In terms of a typical work week, again, it's very dependent on the agency. All of the government attorneys that I know work at least 50 to 60 hours a week. Right now, everybody in my office is working what I would consider to be law firm junior associate hours, 80 hours or so per week, sometimes more. But that's pretty rare. I mean, right now we're working a lot because we've got to help our clients adapt to the shifting circumstances brought on by the pandemic. We are also doing a lot of legal research because the statutory and regulatory landscape is changing really quickly as Congress and state legislatures and a variety of government agencies respond to the pandemic. So I've been doing a lot more legal research than I'm used to because I've been in my field for 20 years, so I tend to just know a lot of this off the top of my head because I've spent so much time with it. But new laws, new regulations require additional research. Unfortunately for me, government attorneys do not get paid like law firm attorneys, even when we are working law firm hours. But I personally see being a public service attorney as really one of the most important things that I can do. Supporting research, supporting our students' education, that's really important to me. And so to me, that's worth more than a paycheck of private practice. It can also be really, really fun, and you learn some interesting stuff. One of my favorite all-time projects was being embedded with the visual imaging team for the NASA Cassini mission to Saturn. I got to sit there with that team, as they use the cameras on the satellite to navigate through Saturn's rings. So I actually got to see that in real time, or well, on an 11-minute delay because it takes time for the picture to come back from Saturn. I was also there when they discovered the water jets that were spewing into space from the moon Enceladus. I got to watch a client drive a Mars rover. I've been lucky enough to get to see a trapped ion with my bare eyes in a quantum physics lab that I support. I have pulled racks filled with 30 pounds of honey from beehives, stood next to the core of a nuclear reactor, negotiated with the NFL, and visited NSA headquarters. So I do plenty of sitting at my desk researching and writing, but working at a university really provides this depth and breadth of legal work that I haven't seen elsewhere. Although I imagine that providing legal support to a city administration is probably somewhat similar. All right, I want to talk about why you should work with your attorney at the outset. And that is because an ounce of prevention really is worth a pound of cure. So as we've seen throughout the course, administrative law in its various forms, it underpins all public sector activities. And the best way to understand the law and how it applies to you is to sit down with your attorney and talk about it. Figure out how the law applies to your organization and also to your specific program within the organization. Your agency's legal office is there to support you and your mission and to protect you in your role as agency personnel and to protect the organization and the mission from legal liability. Effective agency action, it requires coordination and communication. You don't want to waste time and resources coming up to speed with your attorney if you're already in the midst of a crisis. It is much better to spend time building a proactive relationship with your attorney before you need them. Now, I recognize that cultivating an attorney-client relationship can be difficult, particularly if you work for a large organization and your legal office is not in the same building. That's why I feel that it's important to get out of the legal office and go spend time with my clients in their offices, labs, field stations, wherever they are. And if I have a client in a totally separate location that I can't easily get to, and if I've had clients who are stationed in, say, the Democratic Republic of Congo, obviously we're not going to have an in-person meeting. But I do try to have a phone call or a video conference with them at the start because it does create a level of comfort that you don't get via email. Cultivating a good attorney-client relationship, it should be a two-way street. Your attorney should make an effort to get to know you. That can be difficult for your attorney, especially in a large organization. If you think about my university, pretty much I think the same for CU, we've got about 14,000 employees, that's faculty and staff, and over 40,000 students, some of whom work for us as graduate research assistants or teaching assistants. Of those, so we've got 14,000 faculty and staff, 40,000 students, and 9 attorneys. So it's a lot easier for people, out there on campus to know who I am than it is for me to know who they are. So if your legal office is not working to build a relationship with you as a client, I recommend that you take the first step. Offer to meet your attorney for coffee or swing by his or her office to introduce yourself. I will say, not all attorneys are fabulous people. We are just people. They're bad apples in the group. If you're stuck with a bad attorney, I'm sorry, and there's not much else I can say. Do work with your attorney whenever you are developing programs and procedures. You should work collaboratively to detect, identify, examine problems that might occur. These can be both operational and legal. And while your attorney is there to provide you with legal advice, he or she may also be able to red flag some operational issues for you, especially if the attorney's been at the organization for a long time. You and your attorney should develop effective strategies that allow operations to proceed quickly and effectively. This is especially important in emergency management because those operations need to be in place and deployed in real time in response to an emergency. You don't want to have to stop and check to see if something is legal when you're in the midst of responding to a crisis. Now, sometimes that's unavoidable. You just have to move forward without prior legal review, in which case document the reason that you did not seek legal review and loop in your attorney as soon as possible. One good way to sort of build a relationship, work in unison, is to engage in training activities together. Invite your attorney to attend one of your staff meetings. Provide your attorney with an overview of your unit's mission and the people within your unit. Or ask for a quick training session about a topic that is of interest to you or your unit. For example, I routinely make my way around our various schools, colleges, and other campus units to provide training on things like responsible conduct of research, public ethics law, intellectual property, and other issues that are of interest to the university's faculty and staff. You want to collaborate with your attorney and engage in mutual learning. So you want to develop processes. You don't want to just demand answers from your attorney. You should find the most effective way to elevate issues to the legal office. That's very dependent on the agency that you work at, how hierarchical it is. My personal feeling is that, I support several large divisions on our campus, and anybody who works for those divisions is more than welcome to contact me whenever they want to. But some divisions actually want it to go up the chain of command within the division and then have an associate director or a director decide that it's time to contact legal. So that's something, that's very dependent on your agency. But ask your legal office to help you identify legal issues and concepts, and then address those big issues together. Learn core concerns and how to reasonably handle them. And part of this is learning from each other. As non-attorneys, clients need to know, prior to an emergency about any ambiguities that are inherent in the laws, so in the statutes or the regulations that you're carrying out. Attorneys, we need to learn what kinds of legal advice are best for you as the client. Is it best for you if I give you an email with like 3 very concise bullet points, or would you prefer a 2-page memo? It's very dependent on who you're working with, and we all have to also remember that the other side is human. So your attorneys are human beings, and we're aware that our clients are human beings. One thing that you can do to learn from each other is to, as I said earlier, invite your attorneys to participate in your departmental meetings and trainings. I love it when I get the opportunity to do this, both because I see cool stuff. For instance, we've got a burn house on campus, and if they're going to do trainings in there, I might be able to go over and see them. But it's also good because it lets me get to know people within the department, and then they can feel more comfortable asking me questions. You also want to involve your legal office in planning your major projects and developing policies. And you would think that would be a no-brainer, but it's actually overlooked quite a lot. A surprising number of policies and procedures go out without anybody ever having asked legal. So for instance, the Congressional Research Service found that a lot of state-level pandemic influenza plans completely lacked a legal perspective. Half of those plans had no information about laws regarding isolation and quarantine. And of all of the state-level plans, only 2 included procedures for judicial review. So if you're going to quarantine somebody, particularly if you don't know that they're sick, that person is going to say, well, the government has effectively, put me in prison almost, and they might have the right to due process to see if they really have to be quarantined. So you're forming a strategic alliance with your attorney. You want to maximize that relationship. And so the important starting point is to understand that your legal office is there to help you and protect you. In many organizations, the legal office is kind of viewed as the office of no. And in some organizations, that's very true. I mean, lawyers are people. People have different risk tolerances. But in my view, in the view of many of my colleagues, we only say no when it's a very, very clear no. Every other time, we're there to help you get to yes, just to do it in a legal way. So you should be working with your legal department. Don't work around us. When you talk to your attorney, provide complete and accurate information. It should go without saying that you should not lie to your attorney. And I have found throughout my career, there have been a handful of people who have lied to me, and that usually bites them later. But more likely, I'm just not getting complete information. And a lot of times that's because my clients feel that they don't want to waste my time, or they don't think something is important. I had one client who did not give me some really vital information because he thought it was hearsay. But of course, hearsay is it's an evidentiary issue for litigation. It doesn't mean that you can't actually talk to your attorney about something that you don't have firsthand knowledge of. You want to be a good client, don't be rude, don't be difficult to talk to. If your attorney asks for documents, try to get them, to your attorney as quickly as possible. Know your own subject matter and ask specific questions if you have them. As an attorney, I'm always happy to answer questions. And what I tell my clients is, if you're working on something and you think to yourself, I wonder if I should contact legal, the answer is yes. Contact legal. I would much prefer to pick up the phone, have a quick chat, and tell the person, no worries, you're all good, you don't need my input, than to have that person not want to bother me, move forward, and then we find out later that there are problems. And then you should also understand that your agency legal office is really busy. Legal review can take time, especially if we've got to work with other departments, agencies, and especially with external organizations. So be patient if you can, but also feel free to ping your attorney if you feel that you're not getting the turnaround that you need. So you want to use your in-house agency counsel proactively, not reactively. It's much easier for us to help if we understand your operations and we know your concerns in advance. You want to create opportunities to work with counsel so that we do understand your goals, your methods, and your procedures. You should invite your counsel to important meetings and to social events. Don't demand that they attend, but definitely invite them. Have an open door policy whenever possible, and be friendly and engaged. I would say, use time-limited opportunities to engage with your attorney. If you're in an elevator together or waiting in line for lunch, what have you, that's a great time to just chit-chat about a new project. Say, hey, let me send you a white paper on that, and then you can let me know if you've got any legal concerns. For me, it's fine if somebody wants to use me as the bad cop in an external discussion. If I've got a contract manager who's having trouble with a negotiation, I always tell them, feel free to just go ahead and say, oh, my counsel says no. What I don't want is to be used as a bad cop in an internal discussion. And this is where, again, a lot of times clients will try to push supervisory issues over to the legal department and says, you've got to do this because legal says so. Well, no, you've got to do that because your supervisor said so. Not everything that comes to the legal department is a legal concern, and we will push back on that. You also want to understand the nature of your relationship with counsel. Now, this is particularly important if your attorney works for other departments. So you want to understand where the boundaries are for confidentiality, whether the attorney is representing you in your department, and what type of advice you can get. Keep in mind, attorneys, we're there to provide legal advice. We are not there to provide business advice or supervisory advice. We also cannot provide you with personal legal advice because we represent the agency or organization. Now, if you've got a good relationship with your attorney, you can certainly ask personal legal questions as long as you make sure to let them know, hey, this is a personal legal question. Do you mind if I ask? I've done plenty of quick legal work for people that I work with, just because I realize that it's very expensive for them to go and get an attorney. And if I can give them an answer in, 10 minutes or less, I'm usually happy to do that. But I don't do that during the workday. Working closely with your attorney is especially important if you work in emergency management, because emergency managers have to understand and apply the law. And emergency managers have to identify problems in advance. I mean, that's the whole point of all hazards management. And that includes determining the extent to which your agency might be liable when you're preparing for, mitigating, responding to, or recovering from some type of a disaster. These might have gray areas or hidden areas of liability, so it's good to talk those over with your attorney before there's an emergency. And because emergency managers are responsible for understanding and applying emergency management laws, you want to be able to protect the public, you want to obtain the best package of financial support from other levels of government. This is when it's good to include your attorney before the disaster and then during the disaster. So for example, you might have noticed this while going through the Stafford Act exercise, but post-disaster debris removal might be eligible for federal reimbursement, but there are some pretty significant legal requirements that you have to follow. So you want to have your attorney involved to make sure that you can get reimbursed, because debris removal is quite expensive. So particularly in emergency management, prior to an emergency, work with your attorney to understand what powers the governor has to declare emergencies, which activities create the potential for a negligent risk. I mean, there's always risk involved in emergency management, but you want to target the ones that might be risk because of negligence, because you can train your personnel to avoid that. You want to know what rights and liabilities attach to mandatory evacuation orders. We've talked several times, both in lectures and on the discussion boards, that evacuation is one of the biggest areas of liability for emergency management. So you definitely want to discuss that with your attorney. You want to understand, do you have to provide certain standards or criteria for your emergency shelters? And then what happens if you say, okay, community shelter in place, and that turns out to be the wrong decision? There might be liabilities attached for that. So working together is just especially important for emergency managers and their attorneys. You also want to make sure that you are protecting your conversations, that you understand attorney-client privilege. A lot of times people think that if they are talking to an attorney, it's privileged, and that is not necessarily true. It might be confidential, but that doesn't mean that it is privileged. So attorney-client privilege applies if you are talking, attorney to client, if the attorney is providing legal advice. So this is where it's really important not to provide too much business advice, because that can destroy your privilege. The communication has to be intended to remain confidential, and there can't be a reason to set aside the privilege. Now, those are usually when the client is acting in bad faith, so I don't think you really have to worry about that. It's more the confidentiality and making sure that you don't destroy your privilege by disclosing that information to third parties. You should understand whether you are considered a client. If you are working for an agency, you are more than likely considered a client, but it doesn't hurt to ask. It doesn't hurt to ask, too, what types of communications are privileged. If your attorney asks you to apply confidential or privileged markings, do it. So there's attorney-client privilege, but there is also attorney work product. An attorney work product is also privileged, which means that in the event of a lawsuit, the other side won't be able to get to that. An attorney work product is not just work product created by an attorney. It is also created for an attorney. in the course of legal representation, especially if you're preparing for litigation, but you don't have to be. So if your attorney asks you for a memo or to run a query in a database and asks that you market work product, please do, because that's actually going to protect you in the future. Now, there are times when it's going to feel like your legal office is a black hole. Projects go in, nothing comes out. Sometimes legal offices are just slow with no particularly good excuse, but usually your legal office is going to be slow because some type of urgent matter has intervened and or because the workload is overwhelming. There have been times when I sit down with my morning cup of coffee and I immediately get pulled into an emergency. There's a lab accident, investigators are on the scene, I've got to drop everything and accompany my environmental health and safety personnel and my fire marshal to the scene. Or let's say there's a global pandemic and we need to effectively shut down all the research labs, take care of research animals, and pivot all university operations, including health and mental health services, from an in-person to an online format. In that case, I'm probably not going to be able to prioritize a no-cost copyright assignment, with an academic journal, because I'm focused on helping my university get through an emergency. But even under normal circumstances, my colleagues and I are usually dealing with somewhere between 100 and 200 active matters at any given time. Now, this is nothing compared to the workload of a prosecutor or a public defender who might have a caseload of like 2,000 matters, but it's still quite a lot. Additionally, like everybody else, attorneys have to prioritize based on external deadlines and internal hierarchies. If there's a federal investigation or an audit and the university's got to provide a response by Friday at 4 p.m., that's my priority deadline. Similarly, if the university provost or president needs me, that's got to take precedence over the needs of most of my other clients. Another reason for the delay could be lack of resources. Many legal offices, particularly in the public sector, have very limited resources. No support staff, a lot of times no access to electronic legal research tools like Westlaw, et cetera, et cetera. Or your legal office could be waiting on somebody else, either internally or an external party. I've got a client, a faculty member, who keeps checking in because he's worried about getting access to an NIH data set. And I have no doubt that he's eventually going to get access, but there's only so much that I can do to light a fire under the good people at NIH, particularly because NIH is fairly busy responding to the pandemic. Another reason for delay could just be that the client did not involve attorneys early enough. At the university, I often hear that it is better to ask forgiveness than permission. And I would say to you, that is absolutely not accurate, especially if you work for a government agency, because you've got to follow a myriad of laws and regulations as well as your agency policies. In my opinion, it's much better to make sure that you do it right the first time, because it might not be possible to seek forgiveness. This is especially true in my experience if somebody accepts contract terms that violate state law, starts a project without a contract in place, or creates some type of mess that requires a lot of lengthy legal cleanup. It's also really important to provide full and accurate information to your attorney. As I said before, it's pretty unusual to have a client lie to my face. It does happen, unfortunately, but most of the time it's just that clients fail to provide full and accurate information because it slips their mind or they think it's not relevant. Finally, requests can take a lot of time if they are legally complex. If there's not a statute or a regulation on point, or if there is a statute or regulation but it's brand new, attorneys have to spend some time getting up to speed on it and figuring out the best way to proceed. So do try to give your legal office a break, if they're not getting back to you very quickly. But also, like I said, you should feel free to ping them. If you've got a good attorney, they're not going to mind you reaching out for a status update as long as you're not doing it on a daily basis. So just a quick recap of best practices dealing with your agency attorney or other type of in-house counsel. You want to know your legal office, develop a relationship. If you've got a larger legal office, you can request that a particular attorney be assigned to your department. That's sort of what I do. I am primarily responsible for research. So I've got my primary clients. They know that they can call me directly. They know that I will attend their meetings if they need me to. It's good to work with the same attorney if you can. Just because as they become sort of embedded in your department, understand your goals and processes, they can be more helpful to you rather than jumping from attorney to attorney. But that said, there are times when the person you're used to working with needs to pass an issue off to one of their colleagues simply because it's not their area of law. So for instance, although I support our division of research, if somebody comes to me with an employment question about unions, I'm going to pass them along to our employment attorneys who understand that much better than I do. Consider scheduling regular meetings with counsel. I don't mean weekly or even monthly, but quarterly I think is a good idea. That way you can just touch base. This doesn't have to be a special meeting for you. You can simply invite counsel to one of your staff meetings. Work with your legal office to create templates, standard contracts, standard operating procedures. Then have the legal office review them to make sure that they are legally sufficient and you're not leaving yourself open to liability. You can work with your attorneys to develop checklists of potential problems and their solutions. One of the items that I've got uploaded in our classroom for this week is solutions to troublesome contract clauses. This is something that my colleagues and I wrote for the University of Maryland, but it really explains to non-lawyer contract negotiators how to get around some of the more troublesome provisions that we see. Use your legal counsel to educate your staff about various legal issues. So that could be new laws, changes to laws, annual trainings required. So for instance, with HIPAA, you might have to be training people. There might be new and developing concerns in a particular field. It's great to involve your counsel in that. When you're requesting legal work, I highly recommend that you include a deadline, and it should be a reasonable deadline. So, if you give me something at 5 p.m., tomorrow is not a reasonable deadline. But I do like getting deadlines, and I will usually ask for them if my client doesn't tell me, because that way it really helps me prioritize. And then make yourself available to speak with your attorney and provide any requested follow-up information that your attorney asks for. So those are some best practices. Your attorneys should also be doing this with you. Like I said at the start, this is a two-way street. You're building a relationship. There should be trust, professionalism, between you and your attorney. All right, so hopefully this lecture has given you sort of some inside knowledge about the best ways to work with your legal office, how to effectively use counsel. And as G.I. Joe says, now you know, and knowing is half the battle. All right, we have reached the end. Due this week, we've got our discussion 10, which is an Ask Me Anything about the law. And also, I'd love to get your feedback. I always solicit student feedback, and I use that, to make the next iteration of this class even better. You do not have a final anything. D10 is going to be the last graded item. I've decided, as I put in the announcement, due to the pandemic, due to the impact that it's having on a lot of you, particularly those of you involved in emergency management, I did not think that it would be fair to make you go through the process of writing your policy analysis memo. But if you would like to submit a policy analysis memo summary, you can do so for extra credit. It's due the same time that the policy analysis memo would have been due. And again, if you've written your policy analysis memo, or for some reason after this class is over, you really want to write it, please feel free to send it to me. I am happy to take a look at it. I'll review it. I'll provide feedback. That's the case even if you don't get it done by the end of this semester. You can feel free to reach out to me over the summer or next semester. So that's it. Thank you so much for sticking with me again throughout this semester. I know it's been more challenging than expected. Congratulations to those of you who have reached the end of your program and are graduating. And then stay safe and well. I will see you on the discussion boards, but otherwise, I hope that you have a great summer, and that the semester ends well and easily for all of you.